not, the record reflect that we've been rejoined by all the members of our jury panel. Good evening, ladies and gentlemen. Ms. Clark.
Thank you, Your Honor. Good evening, ladies and gentlemen. Well, we're really hanging out together today, aren't we? I hope you all had a real good dinner. I'm going to conclude my remarks for you at this point in about, I don't want to say exactly what time. Lawyers are always wrong, but I really think it'll be about half an hour. Okay, and I'm going to talk about the law of premeditation, and that means first and second degree murder. Let me tell you briefly what I forgot to tell you in the very beginning. In all criminal cases, because the people have the burden of proof, I argue to you first, and Mr. Darden will then argue to you. That's the prosecution. Then the defense will argue. Then, because we have the burden of proof, we get to argue again. We get the last word, so to speak. But it's fair because it's our burden. Okay, so you're going to hear from me again. I'm making now to you the bulk of my remarks. I hope and pray not to be taking as much of your time when I stand up to speak to you again at the conclusion of the case. So I just wanted to let you know that that's the order of things. That's the way it goes in criminal trials. All right. So let's talk about the degree of murder. Is it first or is it second degree? Because you will be asked to determine this question also. And you'll have the law of first and second degree murder back there. And if I can give you a hand in stepping through the law to understand how it applies to the facts, I'd like to try and do that now and be of some help to you. The defendant is charged with 2 counts of murder. And you're going to decide whether they are first degree or second degree. And in order to do that, what you do is you apply the law to the facts. That's what a judge does. And it's actually much simpler than it sounds. And let me start with the basic law of murder. Legally speaking, what is murder? Written forms back in the jury room with you, so if you have questions, you want to talk about them, you can go over them again. All right. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of Section 187 of the Penal Code. Okay. In order to prove such crime, each of the following elements must be proved. Number 1, a human being was killed. Ronald Goldman and Nicole Brown were obviously human beings. Element satisfied. 2, the killing was unlawful. And what they mean by that is that there's no legal excuse for the killing. That's not even an issue here. 3, the killing was done with malice aforethought. Okay, that's the issue. Let's talk about that. Malice can be either express or implied. In this case, the only issue we have is express malice. What is express malice? Express malice aforethought means that a person had an intent to kill where there was no lawful reason to do so, and malice does not require any hatred or ill will of the victim. So, for example, regardless of whether the defendant liked or disliked Ron Goldman or even never knew him, malice is shown if the evidence shows that he intended to kill him. Now, how do you determine if there was an intent to kill? We're not talking about premeditation. We're talking about an intent to kill. How do you prove that? Look at the pictures. This one is proven easily when you look at the nature of the injuries that were suffered by the victims in this case. The unlawful intent to kill is very obvious. These victims were virtually hacked to death. So you have malice shown in the nature of the injuries, the nature of the wounds that were inflicted upon them. So malice, express malice is shown. Just look at the pictures. Aforethought, malice aforethought, what does that mean? That just means that the intent to kill was formed before the actual killing occurred. It's not an afterthought. That doesn't mean premeditation or deliberation, and we'll talk about that in a minute. And again, with the nature and the number of the wounds that were suffered by these victims, It's very obvious that the killer went to great lengths to disable and kill them with the throat-slashing wounds alone. The preformed intent to kill is very clear. In fact, malice aforethought in this case, again, it's proven so clearly just with the coroner's photographs and the pictures of the victims at the crime scene where they were found. So you look at those photographs, you can see that there was a preformed, even if it was just a second before, intent to kill these victims, and a great effort made to kill the victims with the nature of the wounds. And there you go. We've applied the law to the facts, just like you'll do back in the jury room, to determine what was done. Let me give you an example aside from... Let me give you an example. This was a case I remember from a while back. A very simple example of second-degree murder. In this example, a young man was standing on a street corner with his girlfriend. Another young man came and drove up to him on a bike, rode up to him on a bike. He asked the young man on the corner, "Hey, where are you from?" The young man on the corner responded, "I'm not from around here." Young man on the bike pulled out a gun, shot him to death. Second-degree murder. In that example, you have a preformed intent to kill, although no evidence that the young man planned to kill when he first rode up on the bike. But it was preformed in the second that the young man on the corner said, "I'm not from around here." Second degree. Because when he pulled out the gun, he clearly meant to kill, even though it was what you'd call a rash impulse. That's second-degree murder. At a bare minimum, in this case, at the very, very, very least in this case, we know we have second-degree murder. That's the very least that we have. But now we ask, do we have more? Is there more? Do we have evidence that the murders were of the first degree, that is premeditated and deliberate? In asking this question, what we're really asking is whether there is evidence that the defendant weighed and considered the question of killing and the reasons for and against the choice, because that's what we're talking about in terms of premeditation. The answer to this question, just like all the others, comes from the evidence. We look to all the evidence in the case and we ask, is there evidence of planning? Is there evidence of premeditation in the manner of killing? Is there evidence of preparation for the act of killing? I'll address all these questions right now in the course of the argument, but I can tell you that the answer to these questions is yes. I'll briefly discuss the law with you, and then I'm going to show you how the evidence can be applied to the law to answer all of the questions that, yes, we do have premeditated and deliberate murder. First of all, premeditated. Let me see, I think we have the jury instruction for this. That's okay, I'll just tell you. Premeditated is what it sounds like. It does mean considered beforehand. And it's important to remember here that there is no time requirement. The jury instruction states that the law does not undertake to measure in units of time how long the thoughts of killing were considered before they ripen into something that we call premeditation and deliberation. And the reason for that is very simple. And the law and the jury instruction you have will tell you so. Circumstances vary in each case. Each case is unique, has a unique set of facts, and each defendant is unique and has unique thought processes. And so you cannot say, well, 3 minutes is not enough and 5 minutes is plenty. You can't do that. So it's not the consideration in terms of how much time, because you can premeditate within just a few minutes, even seconds.
This is 8.20.
Instruction. Thanks, Dana. Here's what I was saying. You'll have this in smaller form, and it won't be highlighted, but you'll have it back in the jury room. This is the area I was directing your attention to. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. And that's common sense. I mean, you'd think that, wouldn't you? So the true test is not the duration of time, but rather the extent of the reflection. So even if you want to say, for example, that premeditation and deliberation happened in a mere few minutes or seconds, you're going to have to show that during that time there was deliberation. Deliberation is really the issue. What do we mean by that? Under the law, deliberation means that after giving careful thought and consideration, weighing the considerations for and against, the killer decides to and does kill. And that's really what the crux of the matter is in a premeditated and deliberate murder. Can you show that kind of weighing and considering of the consequences? And this is to be contrasted with a second-degree murder. Because in second-degree murder, you have what is known as just a rash impulse. And do we have that? Here. Oops. Sorry.
Thank you.
All right, here's second-degree murder. I just wanted to give you a chance to contrast it, okay? Murder of the second degree, the unlawful killing of a human being with malice aforethought. We talked about that. That's intent to kill. When there is manifested an intention unlawfully to kill, there's an intent to kill, but the evidence is insufficient to establish deliberation and premeditation, okay? So you have basic murder, murder of the second degree, and then if you have more, if you have premeditation and deliberation, you have murder of the first degree. To give you an example of first-degree murder, let's add to the example I gave you previously of the young man on the bike, goes up and he shoots the young man standing on the corner. To make this a first-degree murder, this time assume the following. Assume that the shooter knows who his intended victim is. Assume further that the shooter's a member of a gang and that the intended victim is a member of a rival gang. Okay? The young man standing on the corner, his gang, recently killed somebody in the kid on the bike's gang. Kid on the bike knows this. He sees the victim on the corner, recognizes him as a rival gang member, a member of a gang that just killed a member of his gang, and he decides, payback time. We're going to get this guy. We're going to show him. And it's my time to do it. And now, knowing who the victim is, knowing what his motivation is, knowing that he's going to pay him back, he rides up to the young man on the corner, goes up to him, pulls out his gun, shoots him at point-blank range. There's first-degree murder. He's got a premeditated and deliberate idea of what he's going to do and why he's going to do it, and then he goes to and does do it. Now, in this example, we see the evidence of planning. And we see the cold, calculated decision to kill that is all accomplished very rapidly when he sees and recognizes the victim as a member of the rival gang. Here's a non-criminal example of premeditation and deliberation. This is something that, to show you that we make decisions that are premeditated and deliberate every day. Let's say that you come downtown with some of your friends. You come downtown to have dinner one night. Go into the restaurant, have a good time, hour gets late, and by the time you step out of the restaurant, the streets are almost deserted. Very, very little traffic on the streets. You and your friends walk to the corner, and when you walk to the corner, you see that the don't walk sign is flashing. But it's late, you're tired, you don't want to wait. The don't walk sign is flashing. You step out, you look this way, you look that way, you don't see any traffic, you cross the street. As you stepped off the curb, that was a premeditated and deliberate decision. Didn't take very long, but you weighed the consequences, pro and con. You said, well, I could get in trouble, there might be an officer around, I might get busted for jaywalking, but then again, it doesn't look like anybody's there, and it's probably okay. And you cross the street. Premeditated and deliberate decision. So you can see why it doesn't take long. It's not the length of time, it's the quality of the time spent. Okay, so that's first degree and second degree murder. Second degree, a rash impulse, intent to kill with no premeditation and deliberation. First degree murder, premeditated and deliberate, a weighing of the consequences, pro and con, and a clear and deliberate decision to act, and then the murder. Now the question is, do we have evidence of the premeditated and deliberate type in the murders of Ron Goldman and Nicole Brown? As I've told you, the answer to this question is yes. Now, I'd like to break down this evidence into three categories. For me, this is the easiest way to analyze a case to see if there is premeditation and deliberation, and I hope it works for you too. Here's the first category, is motive. Do we have motive? Now, under this category would fall the subject matter that Mr. Darden is going to address, so I'm not going to discuss it with you other than to mention that the past episodes of domestic violence between the defendant and Nicole, that evidence is evidence of motive. I'm not going to say any more about that because Mr. Darden will address it. The next category is planning activity. What did the defendant do that shows us that he was planning to commit murder? Okay, now I'm going to come back to those questions I asked you to bear in mind early in the argument. Remember when I asked you, think about this? Why did he go out, why did the defendant go out and ask Cato for fives for the sky cap to break the hundreds that he had if he was already going to go out and eat? Remember I asked you that in the beginning of my argument. The significance of that, of asking Cato for the fives, to asking him for change, when he already knew he was going to go out and get something to eat and could obviously get the change at that point. He obviously didn't need Cato to give him those fives, so what was the point? And even when he went out with Cato and he got the change back, he didn't keep it. So getting change from Cato was not the point. And none of his conduct is consistent with what he's telling Cato. None of it makes sense unless you look behind the words. What was he doing? What he was doing was he was setting up an alibi with Cato. He's going out to see Cato so that Cato can say that he saw him. Then Cato can later say, I saw the defendant. I saw him at 9, 10 after 9. He told me where he was going. He said he was going to get something to eat. So if it is discovered that his whereabouts are unknown during the time of the murder, he at least has someone to say, well, wait a minute, he told me. He has a non-criminal explanation for where he was. So he comes up with a pretext of needing change for the sky cap. And it's a good way to remind Cato that he's going to be out of town, too. He'll have Cato remember that alibi also. I need change for the sky cap. Unfortunately, Cato stepped in his way. Cato invited himself along. And the defendant would have been hard-pressed to refuse. Because think about that. If Cato's going to be his alibi to tell anyone who later asks that I saw the defendant at thus and such a time, and then he said he was just going to go out to get something to eat, and then he says, you know, but I tried to invite myself along, but he wouldn't let me go with him, then you have further evidence of consciousness of guilt. Then it's going to look suspicious. Why did he let him go with him? What's the big deal? I mean, he lets him live there. So the defendant agrees. Take Cato with him. This unexpected development, however, eats up time for him, time that he could have had out thinking about what to do, something that he was getting ready to do, getting ready to commit the murders. So instead of going to a real restaurant, which he had the time to do, at 10 after 9, the limo isn't going to get there till 10:45. Even if you assume there's some packing to be done for a one-day trip, how long does that take? They could have gone to a restaurant. But no, they didn't. They went to McDonald's and they went to a drive-thru, the quickest way you can possibly think of to get some food. And he went there in the Bentley. Now think about that. Why take the Bentley? Why not take the Bronco if all you're going to do is go to McDonald's? Unless there's something in the Bronco you don't want Cato to see. The knit cap, the knife, the gloves. If Cato sees those on the night that he intends to commit those murders, before he has committed them, and the police get to him and say, what did you see? Where were you? I mean, what did happen? What happened in this case? He's going to say, that knit cap. I know where I saw that. These things have to pass through his mind. Now, he's got these things in the Bronco. He doesn't want Cato sitting in that Bronco with him. So they took the Bentley. Now, once they got their food at McDonald's, the defendant eats his in the car all the way home. Why do that? You got plenty of time to take it home, eat it in your house, relax, live a little. It doesn't have to be rushed like that. But he eats it quickly. Why? Because now his time has been eaten up by Cato coming along, time he doesn't have. Cato saves his. And it was interesting because he complained about being tired. It was about, what was it, 20 after 9, 25 after 9? They were in the car on the way back, I think it was. And he complained about being tired, and Cato said, well, why don't you take a nap? He said, well, I've got no time. When I heard that, got no time, the limo, it's 9:25, the limo doesn't come till 10:45. You got time to lay down, unless you're planning on doing something else. But what was really telling was after they got back, when they both got out of the car, and Cato walked straight for the house, and the defendant stood there by the Bentley, not moving, watching Cato. Why do that? Why do you stand there and wait? Why not go in the house? Why not get back in your Bentley or get in the Bronco? Why do you wait for Cato to get out of sight? Unless you don't want him to see where you're going. Unless you have it in mind that you're not going to go back in the house. You don't want to take the time to do that. And you don't want him to see you going to the Bronco. Now, there's much more evidence of planning. Planning that you see at the crime scene itself. And in that, I mean the defendant wore dark clothing. The dark blue, black cotton sweatsuit that Cato described, perfect in the nighttime if you don't want to be seen. The dark blue, black cotton fibers that were found on Ron Goldman, the socks, the Rockingham glove, the fibers of the clothing he wore. The watch cap and the gloves. It was June the 12th, the summer night. Why do you need these cashmere-lined gloves and a watch cap on a summer night? Unless you're going to commit a crime, unless you're planning, unless you're preparing to commit a crime. Gloves are easy. Why wear the gloves? Fingerprints. You don't want to leave fingerprints. And he didn't. You heard from the print people he didn't. Watch cap. A partial disguise. If he has to walk around the house, if he's going to be standing at the front gate, he doesn't want someone glancing to make the immediate connection. He doesn't want someone to see exactly who it is right away. Now, he doesn't intend to be there but a minute. But a watch cap over that head is going to make somebody, that doesn't look like something that he would wear, and it throws someone off. Now, those items alone show clear evidence of planning activity, planning for a murder, preparation. But there's more. There's also timing. And by that, I mean, we know that the children were asleep at the time these murders were committed. We know that from the evidence. But who else would know when the children were going to be in bed? Who else would know when they would be safely out of the way? Who else would know when Nicole would be home alone with the children? Who else would know the perfect time to attack and get Nicole without the children being in the way? the defendant. And that not only shows premeditation, it also shows identity. Who did it? Now, there's one more thing that shows evidence of premeditation and deliberation, and that's the knife. In the inventory tape that you have in evidence, the defendant's closet is shown. And it's shown that he had in that closet a gun. He had a gun, but he chose a knife. And this choice is evidence of planning. A gun makes noise. A knife doesn't. Particularly if your intended victim is half your size. A gun is registered. It can be traced. And bullets can be matched to guns. And even if you get rid of the gun, the type of bullet can be determined. It can be determined to have come from the type of gun you used to have. So if you get rid of the gun, it's looking even worse, almost, than if they catch you in possession of it. Suddenly don't have the gun after your wife was shot to death, and a bullet that could have come from that gun, but not a knife. A knife can't be identified to the exclusion of all other knives in making this wound or that wound. You can't match a knife to a murder. A knife isn't registered. All of these things make a knife a better weapon of choice than a gun. But maybe more than all of that, a knife is up close and personal. And that's the kind of murders these are, ladies and gentlemen. These murders are up close and personal. If your desire is to vent your rage on someone, a gun is far too sterile. It's far too removed. But a knife, it's lethal, but it affords the opportunity for the expression of violence, power, and control at very close range. The choice of a knife is evidence of planning, and it too is also evidence that the defendant is the murderer. Now, there's more evidence of premeditation and deliberation in the nature of the wounds themselves. Let's start with Nicole. As I previously discussed, Nicole was incapacitated very quickly. She had little, if anything, in the way of defensive wounds to her hands, and she had no opportunity to defend herself. Likewise, the 4 wounds in close proximity on the left side of her neck, very close to one another, they indicated very little resistance, and they suggested that she was controlled or otherwise incapable of moving away to avoid being stabbed. And the gaping neck wound, the final coup de grace that nearly decapitated her, that is classic evidence of a cold, calculated, premeditated murder. Now recall that this was a wound that was 3.5 inches deep, severed both carotid arteries and both jugular veins. This wound was so deep that the tip of the knife took a 1/4-inch gouge out of her vertebrae. As you recall, and I've discussed it before, when this wound was inflicted, Nicole was incapacitated and helpless. There was no resistance indicated in the wound. The edges of the wound were smooth. And I told you there was something else that indicated she was unconscious, and that is this. The evidence of her knuckles, unbloodied in an area where blood had already pooled around her, showed that she was incapable of raising her hand to protect herself, incapable of raising her hand to try and ward off the knife or the hand that held the knife. No, the knuckles stayed in contact with the pavement and didn't get the blood on them that they would have gotten had she been able to raise a hand to do something to protect herself. And it's further evidence of her unconsciousness at the time that that final slash was inflicted. Now, you remember, as I indicated to you earlier, the testimony indicated that the bleeding into the contusion in her brain showed that she lived for a minute or more before that final throat wound was administered to her. Now, that final gaping wound in her neck was inflicted upon an unconscious victim, or at the very least incapacitated, is clear evidence of a cold and calculated decision to kill. When a victim is already incapacitated and the defendant goes back to her, pulling back her head, she's lying there basically unconscious. He pulls back her head and he slashes the throat to such a degree that she's nearly decapitated. That was a cold and calculated decision to kill, to make sure she was dead. And it allows for no either reasonable inference. Now, Ronald Goldman. Now, once again, a very significant point with respect to Ronald Goldman. As with Nicole, the neck is the target, once again. And we know that from the neck wounds on Ron described by Dr. Lakshmanan. Why the neck? Why is the neck the target? Because it's a sure kill. It's something we've all heard about. Go for the jugular. You go for the jugular because you cut it, you slice that neck, that person's dead. That's a sure bet. That's a sure thing. And the fact that the neck is the target for both victims indicates to you also a cold and calculated decision to kill. That is the epitome of a premeditated murder. Now let me point out with respect to Ron, you have those two wounds. You recall those two lines across the neck, almost parallel to each other, with very little bleeding in them, that Dr. Lakshmanan indicated were inflicted early on in the struggle. Their evidence, and the reason they're important, is that they're evidence that the defendant controlled Ronald Goldman, controlled him to the point that he could hold him and draw the knife across the neck in lines that were nearly parallel to each other, holding Ron from behind him, left arm around him, with the right hand drawing the knife. And Ron struggled to break free of that control. And because he struggled and because he put off the fight, it took the defendant a little longer to incapacitate him than it did Nicole. And you've heard the cross-examination, you've heard the defense attempt to say that Ron Goldman fought with his attacker. Ron struggled, but it was not a struggle with the defendant. It was a struggle to save his own life. It was a struggle to escape. The defense wants you to believe that Ron fought, that he punched the defendant. This was not a fight. And the reason we know this was not a fight was that Ron's palms are cut. For your palms to get cut, your hands have to be open. If your hands are in a fist, you're not going to get your palms cut. It's just as simple as that. And Ron's palms were cut because his hands were up as he was trying to ward off the knife, trying to defend himself. And those abrasions on the back of his hands that were made so much of, they are fully consistent with Ron flailing back, hitting the trees, hitting the sapling, hitting the fence. There were so many areas for him to hit and get those abrasions. Abrasions that are not at all consistent with a fist hitting a face or a body part. And if you look carefully at those photographs, you'll see what I mean. A fist hits a face and you're going to get more than just one little scratch in one little area. You're going to get much more than that. You don't have it here. And the reason you don't have it here is that you have evidence on the back of the hand that shows Ron Goldman falling backwards, as you know he did by the blood on the fence behind him. There's no question about that. And you have his blood on the stump that he's around. You have a lot of evidence to show you what happened here, and it wasn't a fight. This was not a fight. To call this a fight is to call drowning swimming. The sheer number of wounds suffered by Ron as he struggled to pull away, to escape, the sheer number of these wounds is consistent with only one thought. Ron Goldman must die. But beyond that, there is evidence in the wounding that the murder of Ron Goldman is of the first degree. The wound to his left abdomen, if you recall that one, the one that severed the aorta, a wound that ordinarily would have bled profusely into the abdominal cavity. And you expect to find all of that bleeding in the abdominal cavity if the blood pressure is normal. If the person is breathing, that blood pressure will force the blood into the cavity as a result of the wound to the abdomen. but there was very little blood to the abdominal cavity. And like Nicole's final wound, there was no evidence of movement on Ron's part. The margins of the wound were clean, which indicated that there was no resistance offered by Ron. And this wound was inflicted when Ron was very near death already. It was an unnecessary wound. It was a wound inflicted to make sure that Ron was dead. And it shows that the defendant took great pains to go back and deliver the final coup de grace to Ronald Goldman. But no matter when each wound was inflicted or in what order, the bottom line is very clear. The defendant could not leave a witness alive to tell what he saw. He had to deliver the fatal blows and make sure that they were fatal. The defendant surely didn't anticipate that Ron would be there that night. He came to murder Nicole. But once Ron showed up, he could not allow him to walk away with the knowledge of what he had seen. Ron was a witness who had seen what no one was supposed to see. Ron was the ultimate threat, so Ron had to die. And the intent to eliminate a witness, ladies and gentlemen, is a premeditated and deliberate decision. It is a cold and a calculated decision, and it is not a decision that takes very long. As I pointed out before, the jury instruction tells you the law does not undertake to measure in units of time the degree of thought that goes into the thinking called premeditation and deliberation. And now you can see this is a perfect example of how such a decision can be made in mere moments. The defendant has Nicole Brown down. Ron Goldman comes walking up with the envelope. A witness. And the decision is made. That's all it takes. I can't leave him live. I can't let him stay alive. Ladies and gentlemen, this is strong and it's compelling evidence that proves that the murders of Ronald Goldman and Nicole Brown were premeditated and deliberate murders of the first degree. Now, okay, let's address the special circumstances charged in this case, because with all of this evidence of premeditation and deliberation, it is after you determine the degree of the murders that you go on to determine whether the special circumstances are true. Now, if you find that the evidence establishes murder in the first degree as to either Ronald Goldman or Nicole Brown, then you have to determine whether the special circumstances are true or not. Now, in this case, the decision is very easy, because the only special circumstance that we have charged is multiple murder. And for this special circumstance to be found true, the defendant must be found guilty of both murders, first of all, obviously, and then, secondly, at least one of the murders has to be determined to be murder in the first degree. So if you find murder in the first degree as to one victim and murder in the second degree as to the other, the special circumstance is true. If you find murder in the first degree as to both victims, the special circumstance is true. However, if you find murder in the second degree as to both victims, then you must find the special circumstance not true. Now, the defendant is also charged with having used a knife, a deadly weapon, or dangerous weapon in the commission of these murders. And if you do find him guilty of the murders, of course, that decision is very simple. It was obviously a knife that was used to commit these murders. Now, ladies and gentlemen, we've proven with all this evidence that I've reviewed with you easily beyond a reasonable doubt that the defendant committed the premeditated and deliberate murders of Ronald Goldman and Nicole Brown. And I spoke to you before a little bit about direct and circumstantial evidence. This is what they call, well, this is a physical evidence case, obviously, and they call it circumstantial evidence. Now that I reviewed all of the evidence, you can see what I'm talking about when I say a circumstantial evidence case gives you much more assurance of the guilt of the defendant. And that is because of this. In a direct evidence case, you may have one eyewitness to tell you, I saw it. That means you have one thing to rely on. But in a circumstantial evidence case, especially this one, you have many things to rely on. You have the blood at Bundy. You have the blood of Nicole on his socks. You have his blood on the rear gate at Bundy. You have Ronald Goldman's blood in his car. You have his hair on Ron Goldman's shirt. You have the fiber from his clothing on Ron Goldman's shirt, on his socks, on the Rockingham glove. You have the Bronco carpet fiber on the Rockingham glove. You have the Bronco carpet fiber on the knit ski cap. The wealth of evidence in this case is simply overwhelming. If we only had the Bundy blood trail that matched the defendant, it would be enough proof to find him guilty beyond a reasonable doubt. If we only had Nicole Brown's blood on his socks, that would be enough to prove him guilty beyond a reasonable doubt. If we only had Ron Goldman's blood in his Bronco, that would be enough to prove him guilty beyond a reasonable doubt. But we have all that and much more. And now let me summarize for you what we have proven. One piece of the puzzle. We've proven the opportunity to kill. We've given the time window in which he was able to kill because his whereabouts were unaccounted for during the time that we know the murders were occurring. We have the hand injuries that were suffered on the night of his wife's murder to the left hand, as we know the killer was injured on his left hand. We have the post-homicidal conduct that I told you about, lying to Alan Park, making Alan Park wait outside, not letting Cato pick up that little dark bag. His reaction to Detective Phillips when he made notification, when Detective Phillips said to him, Nicole has been killed, instead of asking about a car accident, the defendant asks no questions. We have the manner of killings, killings that indicate that it was a rage killing, that it was a fury killing, that it was not a professional hit. The manner of killing that indicates one person committed these murders, one person with the same style of killing. We have the knit cap at Bundy. We have the evidence on Ron Goldman's shirt of the blue-black cotton fibers, the defendant's hair. We have the Bruno Magli shoe prints, size 12, all of them size 12, his size shoe, all of them consistent, going down the Bundy walk. We have the Bundy blood trail, his blood to the left of the bloody shoe prints. We have the blood in the Bronco, his and Ron Goldman's. We have the Rockingham blood trail up the driveway, in his bathroom, in the foyer. We have the Rockingham glove with all of the evidence on it. Ron Goldman fibers from his shirt, Ron Goldman's hair, Nicole's hair, the defendant's blood, Ron Goldman's blood, Nicole's blood, and the Bronco fiber, and the blue-black cotton fibers. We have the socks, and we have the blue-black cotton fibers on the socks. And we have Nicole Brown's blood on the socks. There he is. I haven't even spoken, you haven't even heard yet about the motive. You haven't even heard the why of it, the why he did it, and you know he did it. Now, these murders did not occur in a vacuum, and it's very important evidence that you've heard in the beginning of this case. They occurred in the context of a stormy relationship, a relationship that was scarred by violence and abuse. And this important evidence completes the picture of the defendant's guilt as it explains the motive for these murders and shows you what led this defendant to be sitting here in this courtroom today. Thank you very much, ladies and gentlemen.
All right, thank you, Ms. Clark. Mr. Darden, are you ready to proceed?
Well, there's no better time than right now, Your Honor.
All right.
May I?
Just want to know if you wanted some exhibits brought up, but if you're ready to go,
I'm ready to go.
thank you, sir. Proceed.
Thank you. Good evening, ladies and gentlemen. You know, they asked me to do the summation Marcia Clark just did for you, but I told them no, it's too long. I'm not the kind of person who likes to talk that long, and Marcia isn't either, but she had to. And I think that one of the things that you probably gathered from hearing her today is that this case really is a simple case in its essence. When you get down to the bottom line, this case really is a simple case. All you have to do is use the tools God gave you, the tools He gave you to use or utilize whenever you were confronted with a problem or an issue. All you have to do is use your common sense. The defense would have you believe that this is a complex series of facts and evidence and law and science and all of that. Not really. Not really. You have to question or wonder how it is that a lawyer can summarize a case in 8 hours when presenting the case took 8 months. It's a simple case. But there's been a lot of smoke, a lot of smoke screens, a lot of diversions, a lot of detractions, a lot of distractions. And in some respects, there's been an attempt to get you to lose focus of what the real issues are in this case. And that takes time. If I could give you any advice as jurors, any advice at all, I would say to you, use your common sense. When you get all of this evidence and go into the jury room, and after you pick a foreperson, take that common sense that God gave you, take the evidence that the prosecution gave you, and the defense evidence. Go into that jury room, sit down, spread it out, and using that common sense, ask yourself a question. What does the evidence show? What does the evidence show? And when you look at it in the simplest terms, what you're going to see is blood in the Bronco, a blood trail from Bundy, blood in his bathroom, blood on his socks. Simple evidence. You can look at a chart and see what the DNA results are. It really, really won't be that difficult when you use your common sense and when you get down to the bottom line and when you put aside all of the distractions and all of the smoke that has been blown throughout this courtroom and in your direction. Now, it's been a long time since I've had an opportunity to speak to you, and unfortunately I wasn't here during jury selection, and so I didn't get a chance to talk to you and introduce myself to you during voir dire, and so you were sort of given the Darden shock treatment, I guess. You saw me literally the first day you came into the courtroom, the first day we began taking evidence literally, and I got involved in the case and we didn't get to talk a lot. But let me say this to you in the limited time that I have. You are an amazing group of people. You've been sequestered now longer than any jury in the state of California. I think Judge Ito alluded to that before. You've spent months in sequestration. I guess you haven't been able to watch your favorite television programs or football. Maybe you missed the NBA season, I don't know. But as you sat there in sequestration, the rest of us, these people, we all got on with our lives. We went home every night. We saw our families and our friends. We continued the personal relationships that we had. And you haven't had a chance to do that for 8 months. And all I can say about that is that you are an amazing group of people. And I thank you for that because you have paid a very, very significant price. You have made a commitment to justice. You have made a commitment to see to it that this case is resolved fairly and correctly. And you made a commitment to see to it that the law is followed, that the police follow procedure in the law, and that there is no conviction in this case unless the evidence is proven to you, unless his guilt is proven to you beyond a reasonable doubt. And I thank you for that. because that's what you should do. That's what the community should do. A trial is supposed to be a search for the truth. And sometimes the truth is uncovered or revealed at the end of a long road, at the end of a long journey. And this has been a long journey. But let me say this to you, that today, tonight, the whole world is watching us tonight. They're watching me. And they have listened to the evidence and they have watched the witnesses testify here on television. And they want to know what you're going to do. And we want to know what you're going to do. So some people, I suppose, who think that justice in this case would be to just ignore the evidence and say he's not guilty. Some people think that justice in this case would be to just jump to some conclusion, some silly conclusion, some conclusion not based on the law, and forget about the evidence. Some people think that because the defendant in this case is a celebrity, that perhaps he is somewhat above the law, that there ought to be special rules for him, or that somehow he should be treated differently than any other defendant. But that's not justice. And there are some people that think that because Furman is a racist, that we ought to chuck the law out of the window, throw it out of the window, that perhaps it shouldn't be applied in this case. Well, that's wrong. And that's not why we're here, because we don't ignore the law just because of the status of a defendant, because of who he is or because of who he knows. That isn't justice. You're here to ensure justice. I'm here to ensure justice. And we all know the rules. And the rules say, and the law says, that he should not kill, that he should not have killed these two people. And the law says that if you believe that he killed these two people, and if you believe that it has been proven to you beyond a reasonable doubt, that you should find him guilty. You heard Marcia Clark, and you've heard the evidence, and you've seen the evidence. And you're reasonable people. And you know, we know. I mean, if we're honest with ourselves, we know. And it's unfortunate what we know. What we know is the truth, and the truth that we know is that he killed these two people.
Object, object to the form.
Now this man, this defendant, O.J. Simpson, we believe that given the state and the quality of the evidence, is guilty. And there's nothing wrong with voting guilty in this case, given the state of the evidence and the quality of the evidence. A vote of guilty in this case isn't a vote for any interest group in particular, or any interest group at all. It isn't a vote for the prosecution, for Marcia and I. It certainly isn't a vote for the LAPD. And it's not a vote against anyone. It's not a vote against the defendant. It's not a vote for the victims or the victim's family. When you go into that jury room, open-minded, and fairly and conscientiously consider this evidence, and then cast a ballot, a vote for guilt or innocence, based only on the evidence that you've seen in this case, and only on the law given to you by Judge Ito, when you cast a vote on that basis, then you're voting for justice. You're voting for fairness. You're doing the right thing under the law. And that's what we're going to ask you to do. Now, they say that justice is supposed to be blind and all of that good stuff. I know you've heard all of that before. But we just have to believe, Marcia Clark and I, that justice is blind in this case. There have been lots of issues that came up in this trial. This trial has been an amazing experience. I'm sure you would agree. But even though there are a lot of small issues, a lot of other issues, a lot of little distractions here and there. You're here to address a single issue. This is a single case. Okay? One issue, did the defendant kill these two people? One defendant, O.J. Simpson. You heard from the defense in this case, and they presented testimony about slurs, epithets as they call them. A bunch of nasty, hateful, low-down language used by Mark Furman. And I'm not even going to call him Detective Furman if I can help it, because he doesn't deserve that title. He doesn't warrant that kind of respect. Not from me. But this isn't the case of Mark Furman. This is the case of O.J. Simpson. And let me say this to you, if you will allow me to, and I don't mean to offend you or demean you, and I hope that you don't feel that I am. But this is the case of O.J. Simpson, not Mark Furman. The case of Mark Furman, if there's to be a case, that's a case for another forum. Not necessarily a case for another day, because today may be the day. But it is a case for another forum. Another jury, perhaps. This case is about this defendant, O.J. Simpson, and the M word, murder. It's not about Mark Furman and the N word. And you know what that is. I want to ask you to consider the fact of his misstatements or lies or untruths, however you want to term it, because you have to consider that. That's the law. You have to consider everything Furman said on the witness stand, because that's evidence in this case, and I want you to consider it. I want you to consider all the evidence. So don't think that I'm saying, hey, just overlook it. Just overlook what he said. Just overlook the fact that he lied about having used that slur in the past 10 years. But I am asking you to put it in the proper perspective. You decide what it's worth. You decide what it means. If it helps you in assessing his credibility, and it should, or his lack of credibility, I don't know, then you use it. But please just remember, Furman isn't the only issue in this case. And his use of that word is not the only issue in this case. And you have to be concerned about that. I have to be concerned about as a lawyer for the prosecution in this case, because it apparently was a very, very significant event for the defense. I mean, you saw all those people that came up to testify about Furman's use of this word. And then at one point, you heard a tape of Furman. And that was Furman, by the way. Okay, no doubt about that, using those slurs. And you heard a tape of him using those slurs. And it had to make you angry to hear him say that. Made us angry. But that wasn't enough. Not only did you get to hear the words, you were given the transcript was scrolled across the elbow. Remember? So you could hear it and you could see it, but that wasn't enough. You had to have a transcript for some reason of the words as well. A lot of emphasis on that. I don't know why. I know you do. But it's evidence, just like all the other evidence in the case. Attach whatever value you think is appropriate. I would say use it to assess his credibility. Any other use you want to put to it, look to the law, look to the instructions that the judge gives you. Ms. Clark mentioned to you that I was going to talk to you about domestic violence, and I'd like to do that right now if I can. And I did that, I suppose, when I began speaking with you back on January the 24th. Was it the 24th? That's a long time ago. You're probably like me. You didn't think it would ever go on this long. Well, you're almost there. It's almost over. But we believe that this evidence of domestic violence is very important. It's important that you understand the nature of this man's relationship with one of the victims in this case. It's important because when you consider it, it may help explain to you, or it may suggest to you his motive for killing Nicole Brown, and perhaps his motive for killing Ron Goldman as well. And the law allows you to use this evidence as you attempt to determine whether or not there was a motive to kill. Can you have Calgic 2.51? And as we search for the motive jury instruction, let me say to you that you can use it for other reasons, for other purposes. This evidence is being given to you with certain limitations, I suppose. And the judge will explain to you what those limitations are. But you can use this evidence to determine whether there's a motive to kill. You can use this evidence to help in the sense of you're deciding whether or not the killing was premeditated. And if you find that it helps in terms of identification, the identification of this defendant as the person that killed these two people. Wrong one. You can use it. But when you look at this jury instruction entitled Evidence of Other Crimes, you see here at the bottom where it says a motive for the commission of the crime charged. You see that you can use this evidence for that purpose. Evidence of other crimes, the 1989 spousal battery incident. You can use that to look to see if there was evidence of a motive. But there's also something called Calgic 2.51, and it's entitled Motive, and it reads as follows. Let me read it to you. First of all, it says that motive is not an element of the crime charged and need not be shown. And that's important. Ms. Clark talked to you about premeditation and malice aforethought and whether the killing is willful and deliberate and all of that. We don't have to prove to you that the defendant had a motive to kill. We don't have to prove that at all. It just so happens that in this case we have that kind of evidence. But motive is not an element of the offense charged. And 2.51 also says that the presence of motive may tend to establish guilt. If you find that we have presented sufficient evidence of motive, then you should use that evidence as you attempt to determine whether or not the defendant is guilty. But you can use this domestic violence evidence for a number of reasons and in a number of ways. And when I spoke to you back in January, I told you, I promised you, I think, that I would expose to you the other side of this man, of this defendant. I promised you that I would expose to you the private side of him, that part of him, the side of him was capable of extreme rage, jealousy, and violence. And I said to you back then, I said to you and I asked of you that you consider the nature of their relationship, his relationship with Nicole. Because to understand what happened at Bundy, you need to know what happened between them during the 17-year period that they were together, off and on. Because when you look at that, you see a motive for killing. Now, I'm sure the defense is going to get up here at some point and say, that domestic violence evidence is irrelevant. And they may say to you that just because this defendant had some marital discord or violence in his marriage to Nicole Brown, that it doesn't mean anything. Well, this isn't a just because issue. This is a because issue. Okay? It is because he hit her in the past, and because he slapped her and threw her out of the house and kicked her and punched her and grabbed her around the neck. It's because he did these things to her in the past that you ought to know about it and consider it. And it's because he used a baseball bat to break the windshield of her Mercedes back in 1985. And it's because he kicked her door down in 1993. You remember the Gretna Green incident? Remember the 911 call? It's because of a letter he wrote to Nicole, rather, around June the 6th, talking about the IRS. It's because he stalked her, because he looked through her windows one night in April of 1992. They may say that the defendant's just looking through a window late at night. We say that's stalking. It's because of all those things, and because all of these things, alongside the physical evidence at the scene, the bloody shoe prints in his thighs, the blood drops at Bundy, the blood on his sock, the blood trail to Rockingham. It's because when you look at all of that, it all points to him. See, I'm not afraid to point to him. Nobody's pointed him out and said, he did it. I'll point to him. And why not? The evidence all points to him. And it's also because when you look at the bloody ruthlessness, my mouth is getting dry, of these murders, and when you see, as Ms. Clark pointed out, that these killings were rage killings, rage, I mean, you have to say to yourself, well, who in the past has ever raised a hand to this woman? Who, during the days and the hours leading to her death, was upset with her? And as Ms. Clark alluded to earlier, you're too kind. And as Ms. Clark alluded to earlier, the killing was personal. The way it was done. The way it was done, this is personal. Somebody had a score to settle. Oh, who had a score to settle? With Nicole. When you look at all of that, you look at the domestic violence, the manner of the killing, the physical evidence, the history of abuse in their relationship, the intimidation, the stalking, you look at all of it, it all points to him. It all points to him. Now, they may not think this evidence is important, but it was important to Nicole Brown. You heard Detective Mark Furman testify about the 1985 incident. And let me say, Furman, let me, all right? I've said Furman about 50 times. Let me let you know this. We're not hiding Furman, okay? He's too big, especially now, to hide. So, hey, Furman testified. Furman described for you the 1985 domestic violence or domestic abuse incident or incident of violence or incident of abuse or disturbing the, disturbing the peace incident, whatever you want to call it. But in 1985, Detective Furman was not a detective. I just call him Detective G. Furman was a patrol officer, and he went to 360 North Rockingham in response to a call. And you recall the testimony. He saw Nicole sitting on a Mercedes, as I recall. The window was bashed out. The fenders were dented. There was a baseball bat nearby. The defendant was walking along the driveway. Furman had a conversation with the defendant. Nicole was crying. Her face was covered with her hair. She was holding her hands to her face. You remember that testimony. That was 10 years ago. 10 years ago, Furman went to 360 North Rockingham. In response to that call. That's 1985. 1994, Nicole's dead. When you look at the relationship between these two, and you reflect back on the testimony from Christian Breitbart, And you think about the 911 calls and Officer Edwards, and you think about the day of the recital. You think about Denise Brown and what she had to say about the defendant. Remember that time at the Red Onion when he grabbed her by the crotch in front of a bar full of strangers and said, "This is where my babies come from, this is mine." Remember that testimony? This relationship between this man and Nicole it's like a time bomb ticking away. Just a matter of time. Just a matter of time before something really bad happened. You know, you meet people in life, and there are people with short fuses. You know, they just go off. And there are others with longer fuses. You know, it takes them a little while longer to go off. And relationships are the same way sometimes, you know, especially violent, abusive relationships like this one. This thing was like a fuse. It was a bomb with a long fuse. And there were incidents along the way. And along the way, as each incident occurred, that fuse got shorter. If nothing else, that fuse was lit in 1985, that night when he took that baseball bat to her car. And we don't know the reasoning behind his decision to do that. We only know that he did. But when you stop and you look at it and you consider the conduct, breaks the windshield, dents the car up, use of a baseball bat, that's a pretty novel approach. The wife is seated on top of the car crying, face covered, hair over her face. If nothing else, look at it this way. What message does that send to Nicole? I mean, what are we going to do with this evidence? How do we evaluate this when a man takes a baseball bat to his wife's car and just beats the heck out of it? If nothing else, it sends a message to her. It instills fear. Wouldn't you agree? And would you agree that it suggests to her that this can happen to you? That maybe you'll be next? See, that fuse is burning. It's burning in 1985. It is burning in 1985, and 1985 was the year of their marriage. The fuse is lit, it's burning, but it's a slow burn. We next go to 1989. You heard from Denise Brown on the incident, you know, she testified about 1989. Detective Edwards testified about 1989. I said before, you got to go back. We have to go back and look at their relationship. We have to go back in the past to see how we got where we are today. Because when you do, you see a pattern developing here. You see that fuse is lit. In 1989, it was New Year's night, and it was about 4 o'clock in the morning. And as I recall, we called to the witness stand a 911 operator, and her name was Sharon Gilbert. And that night, that morning, she received a call. The caller never identified herself. The line was left open. The call came in, the line was left open. The 911 operator stayed on the line and listened in. And as she testified here at the trial, if you stay on long enough, if you're the 911 operator, you get a fix on the origin, the address, from where the call is coming. She stayed on the line. She determined that the call was coming from 360 North Rockingham. And she listened in for a few moments. You recall that tape? Can I play that for you? It only takes a couple of seconds. You have that tape? Is that People's One? And this is People's One. This is the first exhibit I marked for you in this case 8 months ago.
Rockingham, apartment number B.
I stood before you back in January. I said to you that if you listen carefully to that tape, and you have the tape in the jury room, you put it in a tape recorder, and when you listen to it, listen carefully, because you can hear in the background the sound of someone being struck or slapped. And that's what the 911 operator heard. And she told you on the witness stand that she heard that. She heard the sound, the noise of someone being beaten, and she put that out on the radio. Recall that? She put it out on the radio that there was a woman being beaten at 360 North Rockingham. Now, they may say that this isn't important evidence. I say they're wrong. There's physical abuse here, wife beating here, spousal abuse, spousal battery going on. And this is an emergency situation. And Sharon Gilbert, the 911 operator, puts this call out, code 2 high. Get somebody to 360 North Rockingham fast. And they do. And they do. About 4 o'clock in the morning, Officer Edwards arrives at 360 North Rockingham. You recall Officer Edwards, he and his partner. They drove up they drove up Ashford. They passed the Ashford gate. They stopped at Rockingham where he saw the call box. He got out of his patrol car and he pushed the button at the call box, and a voice responded on the other side. It was the voice of the maid at that time, Michelle Abderrahman. Officer Edwards identified himself, told Michelle that he was there in response to a 911 call and that he needed to speak to the person that made the call. Michelle said,